And I want to invite the inspiration, the person that came to see me this summer to ask me to put forward and study the question a little bit more. The bill uses the Saskatchewan model, and this is a work that we've been doing together. So I'd like to invite Michael Johnson to speak to you.
Thank you very much. Good morning. Ontario is beautifully diverse and multicultural. Our citizens have a legion of different backgrounds, beliefs, and personal circumstances. Unfortunately, our juries do not reflect that diversity. There is an undeniable issue in Ontario with the representativeness of our juries. This is obvious, it's not a secret. In 2013, there was the report tabled by the Honourable Frank Iacobucci discussing First Nations representations on Ontario juries. More recently, there's the report to the Canadian Judicial Council on jury selection in Ontario from June 2018. Federally, we have Bill C-75 that seeks to modify provisions in the Criminal Code dealing with jury selection in the name of representativeness. There is a problem and solutions are needed. This private member's bill comes forward today not as a panacea, but as a small but important and incremental step forward. This private member's bill seeks to assist the province in fulfilling its responsibility, as representativeness is really about the province's process in creating the jury roll, the panel, and delivering notices, ultimately leading to the creation of the petite jury. This private member's bill seeks to not redefine totally the law, simply to make it more consistent with what is the law in other provinces, or more specifically in Saskatchewan. The only automatic exclusion of citizens with a criminal record should be if they are serving time as a result of that criminal record. This would make juries more representative, but would at the same time restore dignity to the affected citizens. The Supreme Court of Canada, as I've said, has made clear that representativeness is about the process that's used to compile the jury roll and thereafter the panels and the petite jury. However, the Supreme Court of Canada has also made clear that it is the deliberate exclusion of a particular group that would cast doubt on the integrity of the process and violate Section 11D of the Charter of Rights and Freedoms. Citizens with criminal records are deliberately and automatically, and I would suggest problematically, being excluded by the Juries Act. Citizens who have a criminal record for an offense that could be prosecuted by indictment that have not received an administrative pardon are automatically excluded. In 2015, it was estimated that 3.8 million Canadians had criminal records, with only 11% receiving pardons. In a country of less than 40 million, that is a substantial number of citizens that are automatically being silenced. These are citizens, to be sure, that have the constitutional right to vote in federal and provincial elections as guaranteed by Section 3 of the Charter. They're citizens that have the requirement to pay taxes, and yet they are just automatically silenced. What is it about having a criminal record? What is it about having made a mistake in the past that makes you ineligible? What is it that disqualifies you? Is it because of this belief that people who have made a error in their past are morally corrupt forevermore? It's a discriminatory belief and it needs to be set aside. By eliminating Section 4B of the Juries Act, there is not going to be a substantial change in the legislative landscape. There are provisions to keep individuals that are biased off of juries, and there are even provisions to keep individuals with criminal records off juries, but the federal government casts it at a higher level, requiring individuals to have served time for 1 year of jail or more if they are to be removed. One example that we can bring with respect to the effects that this small but important change will have is with respect to Aboriginals. We know that Aboriginals are unfortunately tragically overrepresented in the criminal justice system. However, the correlation that exists is between the overrepresentation of Aboriginals in the criminal justice system and their underrepresentation on juries. If you're overrepresented in the criminal justice system, that means that there's a likelihood that there's going to be criminal records that ensue. And if criminal records are used to exclude those individuals from serving on a jury, then there will be a disproportionate impact on Aboriginals who are thereby going to be automatically excluded. As a result, this is an obvious, low-hanging fruit for this legislation to realize upon. By removing this automatic exclusion, there will be more citizens that can be considered for jury duty. Whether they ultimately end up on the petite jury is a different question. As already stated, there are provisions to remove individuals if it can be shown that they're biased, or currently, if it can be shown that their records resulted in a jail sentence. Ultimately, this bill simply seeks to adopt what was recommended by the Honorable Frank Iacobucci in 2013, where he suggested that changes be made to bring the Juries Act in line with the Criminal Code. And where the Honorable Nathalie Des Rosiers takes this bill one step further is in appreciating that there shouldn't be any basis to automatically exclude people simply because of a criminal record. If you're going to disqualify citizens from meaningful participation in their community, it should be on some principled basis, like those people are biased, or some other basis that can be shown, not presumed. This private member's bill does take an important small step forward. The issues of jury representativeness are large and complex, but it is important that action be taken, and I thank you very much for your time and opportunity.